for everybody to get connected on Facebook, on YouTube, on Instagram. Welcome, welcome, welcome. So, this is another episode of Live on the Spirit of Business. Today, we're going to talk about a very special topic, which I'm going to read some things to you guys from one of my law books. And we're going to have just a discussion about a piece of, or just one element of what it means to privately govern yourself. My God, I have all this stuff in my hair. So anyway, we're going to talk about what it means to privately govern yourself, and specifically what it means to create your own private law, okay, or private governance. So this is a book that I may have shown you guys a couple of times on my timeline. This is called How to Avoid Probate. How to Avoid Probate. So one thing we know about trust law and about private law is that when you have certain stipulations in place, which is, really on file by the government, when you have these things, hold on for a second, you guys, I need to turn off my headphones because I don't want them to be picking up the noise. All right. So one thing we know about creating private law is that it happens through contract. So we have to talk about what it means to be in this private governing mode or private governing status instead of under the jurisdiction of the federal government. So this is extremely important because when we're talking about private governance and contract law, we have to know the elements of what it means to actually create the law or to create the contracts, okay? Because the contract is the law. And that's the reason why we call it private governance or private law, because we're actually the ones who are creating this law for ourselves. We're not going to the federal government or to any other third party entity to ask for information about how to govern or how to set up this or how to administrate or anything like that. All right. So I want to read to you some things from this book called How to Avoid Probate, because this is how we're going to discuss the creation of the private law through our own contract documents. So it says, it is likely to be a long time before there is adequate probate reform in America. Don't be discouraged, though. You need not be in the system's victim, or you need not be the system's victim. And this is what we're talking about. We're not victimizing ourselves here because there's no need to be a victim. What we're going to do is figure out how the system works, and then we're going to work it. Okay. All right. There exists a magic key. You hear me? A magic key to probate exemption. And when we say probate exemption, we're really talking about tax exemption. We're talking about tax exemption, a legal wonder drug that will give you permanent immunity from the racket. Again, this is about private law. You are avoiding the governance of the federal government. Okay. You are getting permanent immunity, okay, from the racket. That means racketeering for anybody who was wondering. The magic key is the inter vivos, or the living trust. Okay, a financial bridge from one generation to another. All right. And so this is how the wealthy stay wealthy. They use the inter vivos living trust along with many other trusts in order to create their personal governance laws over their businesses, over their assets, over their, any accumulation of things. Okay. Any accumulation of things. And that's their physical real property, and that's also their intellectual property. That's also their biological property. We're talking about their children. We're talking about all their worldly possessions, and we're talking about their assets or other intellectual, or I should say intangible assets. All right. There are two types of trust. The most common is the testamentary trust. Okay. They call that testamentary is because it is established under the provisions of your last will and testament. Okay. Your last will and testament. This is thy will be done as it is testified by you, because you are the creator. You are one with the creator. So what you say goes. Your will be done. Okay. You might, for example, direct the executor under your will to turn the net proceeds of your estate over to a local trust company, which would invest the money and distribute income and principal in accordance with the instructions contained in your will. This is the reason why we call this private law creation. Because if you are creating the law, you're doing that by way of writing documents that are contracting with you yourself, and other parties, which would be your executor, which would be your trustee, which would be your beneficiaries, or anything like that. You're going to be in contract with these people. And that's the reason why this book calls it a permanent immunity from the racket, because your contract is never expiring as long as it follows the rules of what we call perpetuity. Okay. The law of perpetuity in contract law or in trust law says that your trust will be forever valid as long as the stipulations are applicable in time. Okay. So that means you cannot say, well, I want this rule to be in effect forever, because forever may not be feasible according to what you're actually trying to say. All right. So this testamentary trust would not become effective, okay, until your will had passed through probate. With all of that, with all of the delay, expense, and publicity, which ordinarily attaches to the probate procedure. Now, when probate happens, that means that all of your assets are going through the court system. It means the court is now coming to say, we're going to break all this stuff up because this person has died. And you all know that when most people die, if they're not wealthy, then the probate office or the probate court will come in and say, well, we have to pay these debts. All right, this person owes this much, that much. We're going to pay that out. And then the beneficiaries or whoever is the family member, they're going to get the rest of the money. We know that, right? But that's not how we're going to do this, because we're now we're following these procedures to avoid the probate. It says a testamentary trust serves as a very useful purpose when heirs are inexperienced, and this is talking about the beneficiaries, or likely to be imprudent or profligate in their handling of the funds they are supposed to receive. So it says large inheritances frequently fail to provide the lifetime security which the testators intended. Now, when you are testating, this is your testament. Okay, your testament is the law. It is the contract that you're creating. When the testator intends for there to be some kind of security, it must be included in the will or the trust in order for it to be valid. If it's not valid, okay, according to the stipulations inside of the contract or the document, then it will not provide any security to avoid probate. All right. So it says, indeed, instances abound where sudden wealth has unhappily affected the lives of the beneficiaries. It almost always is better to leave an estate in the care of a responsible trustee. You can choose any trustee that you like to choose as long as they will abide lawfully by the stipulations that you have given in your last will and testament and the trust. Now, a trust is nothing but a set of information that strictly outlines what you want to happen. Okay, it gives a timeline. It gives a subject of the trust, which means what are you talking about? Are you talking about assets? Are you talking about people? Are you talking about money, property? What are you talking about? That's the subject of your trust. And then you have the beneficiaries, the people who are going to be the fiduciaries. Okay, this is your executor, your trustee, these people that are responsible for executing. Okay. One way of doing this, the traditional way, has been a testamentary trust established under a will. Okay, so this is actually one element inside of another. You're putting the trust inside of the will. All right, the will is just one document that contains several trusts. Our concern here, though, is with avoiding probate, and a testamentary trust does not avoid probate. As we have already noted, it cannot come into being until after the probate process is completed. The second and far less well-known type of trust is the inter vivos or the living trust. Few laymen know about the living trust. Layman means layman's terms, okay? Layman's people means just regular people, regular speech. Okay, few laymen actually know about the living trust. Indeed, only a small proportion of attorneys actually know about it or understand how to use it. Okay, and this is the reason why Serve Inc. is here to actually teach these things, because you can go to your CPA and ask them how to avoid probate, and they're probably going to tell you, "What do you mean? Avoid probate? How? We don't do that. Probate is there to handle your estate." And so they'll kind of turn you away and tell you there's no such thing. But we know because of our study, okay, and because of our research, we do know that there are ways to govern yourself without the probate court actually having any jurisdiction over the distribution or dissemination of your property. Okay, so it says at least half of the attorneys who do know of it are they're either going to deny that knowledge or they're going to strongly advise against you to use it, which is ridiculous. Why would anybody advise you against it? The inter vivos trust, you see, is exempt from probate. Probably the reason why they don't want to use it, because if you're exempt from probate, what good do they do? You probably won't need them. Most attorneys derive a substantial portion of their income from seeing the estates of deceased clients through probate. Seriously. Now, do you expect them to tell you how to avoid probate? Exactly. Exactly. That's what I just said. You won't need them. So they wouldn't tell you about the avoiding probate, because then you would be canceling out their fees or whatever they're going to charge you to do this stuff. So he says, I would put the proportion of attorneys who know about it and recommend the inter vivos trust at less than 1% of them, which is sad. Okay, why would you want to do that to somebody? When you set up a living trust, you create it now while you are here, not through the instrumentality of your will after you're gone or after you've gone. In effect, you say, I hereby declare that I hold this property in trust for the benefit of so-and-so. These are your beneficiaries. You name the beneficiaries. You name the trustee who is to distribute the property to the beneficiary. It says, I appoint John Smith as successor trustee, which means that when you have gone, because you're living in your living trust, you are the trustee of your own estate. Okay, when you have the living trust. But after you've passed, then you select a successor. Okay, your successor trustee is the person who you're appointing. So it says, I appoint John Smith as successor trustee, and I direct that at my death, the successor trustee shall dispose of the property as follows, etc. So you start to create your law at this point. Okay, when you are creating private law, after that sentence is when you say you are to do this as follows, this is where you speak the law. This is where you create the law. This is where no other government entity, no matter what, can interfere with the law that you stipulated. Now, there are situations where people, like, let's say, for example, in the Church of Scientology, they have been successful in creating their own private governance, but in their private governance, they have created things that are infringing upon the natural rights of other people. And so we do take into consideration that there are some instances where our law might actually be in violation of the rights of others. So we have to consider that a court may have jurisdiction where there is a criminal impact on other people. So in that sense, that's the only case where you may not be able to govern yourself if you are infringing on the rights or the natural rights of another person. Okay, so it says an inter vivos trust can be either revocable, okay, which means that you can cancel it, or you can alter the terms. Okay, but you have to be very careful about that, because if you need the assets that you have titled to your trust or your your irrevocable trust. If you make it irrevocable, that means you cannot retitle, you cannot get access or disperse while you're living any of those assets. Okay, because the irrevocable trust says you can't change it. You can, if you have a revocable trust, you're good. Irrevocable, anything that you title to that trust is not going to be eligible for you to liquidate it, for you to pass it to another person. You won't be able to change it at all once you have locked it into the irrevocable trust. Okay, so be careful about that. Let's talk about the revocable inter vivos trust. Such a trust offers no tax advantages. On the other hand, it offers no disadvantage. All of the estate and income tax savings obtainable through a skillfully drawn testamentary trust are equally available in a well-known or a well-drawn living trust. And when they say well-drawn, this means that the stipulations are clear. There are some things they call the 3 certainties that you have to have when you create a trust. The 3 certainties are: you have to have the element of a subject. So it means you have to say what is going to be the subject of the trust. What is it that you're talking about? Secondly, you have to have somebody that is going to, a human beneficiary that's going to actually be able to receive this type of property or asset. And then you also have to have somebody that's going to be the executor, or somebody that's going to be the trustee to execute the process of giving out these assets. Okay. So when you have a skillfully drawn testamentary trust, that just means that it is complete. There are no holes in it. When you say that you want something to happen, that it's very clear. You don't have any abstract concepts that nobody can really interpret. And one example that I was studying in case law, listening to my lectures, the lesson was about a particular person who was not able to transfer any of their assets through the trust because they were not clear in the drawing of the trust. They would say something like, I want this money to go towards the goodwill of all men. Well, in a situation like that, you're not really helping anybody. You're not doing anything because nobody knows what you mean by that. And so that's not a very well drawn trust, and you won't be able to actually get anywhere with the execution or the dissemination of that type of trust. Okay, so it says, there are many persons whose faculties or judgment are not so impaired as to justify an adjudication of incompetency, but who nevertheless would be benefited if relieved of the details of handling investments or a business which age or ill health may make burdensome. The living trust offers an excellent solution. Okay, by setting up a trust during his lifetime with someone else as a trustee, a person has an opportunity to observe the efficiency of the individual or the institution whom he has named as trustee. Okay, when you're naming somebody as trustee, you can look at how they're performing as long as you've created this living trust. You can appoint them as a trustee and then make sure that they are performing in that capacity the way you have deemed for it to happen. Okay, it's an opportunity to see your will in action. Your will be done. Okay, so you have to observe and see if it actually is being done. If the laws of the state of his residence are not to an individual's liking, he can avoid them by setting up a living trust with a trustee institution in another state whose statutes he finds more palatable. How powerful is that? How powerful is that? To say, if you don't like the law where you are, you can set up law in another place. What did we say? We're creating private laws, private governance. How do you create a private law? It says you set it up inside of a living trust, okay, with a trustee institution or a trustee individual in another state where you find those laws to be more palatable. Okay, the exemption from probate accorded a properly drawn and executed revocable trust in virtually all jurisdictions materially reduces, if it does not, in fact, completely eliminate the likelihood of successful attack by disgruntled persons. And when they say disgruntled persons, they're talking about people trying to sue your ass. If you are looking at the purpose, okay, of why we're doing this, like this book just said, we're creating a bridge from our generation to generations beyond, or the generations that come after us. So if a disgruntled person wants to sue you and take everything from you and leave you with nothing for your children or your children's children, what can you do to stop that from happening? You can create the revocable or the irrevocable trust. Okay. And so that would stop that person from being able to impose on your will. Okay. It says contested wills are an everyday occurrence. And this contesting means that somebody has objected. It means somebody has some type of objection to your trust or your will. Okay. It says, and estates do not always go to those whom the testator has named to receive them. In the first place, the legal necessity for advertising the fact of a will's having been presented for probate invites the interest, okay, and attention of those who may feel they have a legal basis for contesting the testamentary distribution. Testamentary distribution is what you have stipulated to be distributed amongst your beneficiaries or your heirs. An inter vivos trust is distinguished by its privacy. Again, private law, you guys, private governance, private law. I want you to understand that when you create this type of document, you're creating a private law because you are creating the, what am I trying to say? You're creating the stipulations for yourself. The law, the governance for yourself, all of the will that you're creating, you're saying how you want things to be governed. And there's There are several ways you can do this outside of just a living inter vivos trust or any other type of trust. Okay. So it says this is privacy. It says parties likely to protest may not even learn of the settler's death until long after or long afterward when the transference of the property is a fait accompli, which in a word, it says in a word, the publicity of probate invites attack upon a will. The privacy of an inter vivos trust discourages it. So if we're having the inter vivos trust, that means we're not allowing anybody to come and say, listen, I'm contesting or I'm disputing the will that you set forth. If you're going to announce it to the whole world, it's not private. But when you have the living trust, it becomes private. You're not making an announcement to everybody so that everybody can come and say, oh, I'm supposed to get some of that property or I'm supposed to get some of that payout. No. Okay, it says, I know of no instances of successful attack by a third party upon the legality or the validity of a living trust. All right. Of course, such a trust should not be used to deprive a spouse or creditors of sums to which they might rightfully be entitled. In one historic case, a widow contested the validity of an inter vivos trust established by her late husband 6 years before their marriage. The court denied her claim of widow's rights and held the trust to be inviolate. Okay. Which means that the person, because he met her after he created the trust, he's probably able to retain the property. We have already noted that during the long drawn out probate procedure, the court will allow a limited payment to support a widow. Children and other beneficiaries are not so entitled, however, and the death of a breadwinner frequently results in an interruption of income, which works a hardship upon beneficiaries. So we are doing the inter vivos or the living trust in order to stop all of these things from happening. In the case of an inter vivos trust, the trustee or successor trustee needs only a certification of the death of the settler to fully activate the trust income provisions in the interest of the heirs, which means that at the time that a person has a certificate of death, they can start administering the estate to pay out or to benefit the heirs in whatever way was stipulated inside the trust. There is no delay whatsoever. Okay. This assurance of uninterrupted income and access to the principal within the terms of the trust can be extremely important to a family beset by the uncertainties and financial problems ordinarily attending the death of a breadwinner. This advantage of the living trust is particularly important when there is a business to be run or liquidated on favorable terms. All right, now I want you to hear this because when I go back to the beginning of this book, it tells me all the different ways that I can avoid the probate of different things. So we can do the inter vivos living trust to avoid the probate of our home. We can do avoiding the probate of our checking and savings accounts. We can avoid the probate of mutual fund shares, of securities, closed corporations, life insurance. Okay. Our spouses, we can do specific trusts to give special attention to our spouses. We can leave money to charity. We can reduce taxes. This is called a reversionary trust. We can make a gift to a minor, in which under the law, a minor is not a person who is under age, but is a person who is understanding, which means they are under the intellectual competency to comprehend. Okay. A minor under the law, again, under the law, you have a major and you have a minor. Under the law, a minor is a person who lacks understanding of their rights and their ability to enforce their rights. Okay. A major, like in the military, is a person who is of the understanding and knowledge of how to enforce, and they are aware of their rights. So they're aware of their rights and they know how to enforce those rights. That's a major. So that reversionary trust is about, or excuse me, gift to a minor has to be understood properly. Avoiding the probate of your personal effects, meaning your material possessions. A small unincorporated business can avoid probate. You can avoid probate of your automobile, okay? And you do all of that by entering these different trusts into your will. All right. So we're going to talk a little bit further about how to create these private laws in other ways, because there are other documents. Like, for example, if you're starting a business, if you have a small unincorporated business, how do you privately govern that? Okay. If you have your, what do they call it? A family office. That's one of the best ways where you can self-govern is creating a family office. When you have a family office, you're doing certain things like managing businesses. Okay, you're setting up different streams of income because you must be able to fund and you must be able to manage the affairs of the trust. So when we have, let me show you guys this. This is what the overall structure of a family office looks like. Hopefully everybody can see that. The family office, it is structured with this centerpiece, and then you have all these different legs of the estate. Okay, this is your family who is governing. And I want you guys to know this. Our society is governed by private families. Okay, when you think about the Morgan family, what do you call those people? The Bilderbergs and the Rothschilds and the Gates families. All of these people, they have these things in place because they are governing themselves by way of governing their businesses. All right, so when you look over here, you have business management and development as one part of your as just one part of you governing your family office. I'm trying to see where that is. You have private equity in here, open your bank accounts, financial statements, foundations. You have a family charter. You have a family council. You have legal services. You have creating charitable trusts and foundations. Okay. Managing and monitoring projects, organizing events and collecting funds. All of this about business development is about joint ventures, mergers and acquisitions, the transfer of business, IPOs, networking. Okay. These are all the things that you do in order to govern your own estate. All right. And when you have these things in place, you're not allowing the federal government to come in and give you any type of governance to override what you have put in place, as long as you have a complete listing or a complete system of governance. So when we come back, hopefully we'll come back tomorrow. We'll talk more about what it means to have this private system of governance in your own family. Okay, for your own purposes. Now, another thing we're going to talk about on another day is how we can do this socially. Okay, because right now, this is just for your family. This is just for a single family. But if we're talking about having this done for an entire society, it is possible. Okay, because if we're talking about privatizing governments, this right here can be any entity that we choose as a society. You understand? Or as a family. If several families get together and they say this is how we want to govern ourselves, then that's how we're going to govern ourselves. Okay, so this has been another great episode of Live on the Spirit of Business. I'm going to come back with you guys and read a little bit more out of my books because I have several of them. And we're going to just continue to talk about this. So I want to encourage you guys to go to Serve Incorporated. I'm going to show you really quickly. I'm going to show you real quick. I'm going to show you our website so that you can know how to get to it. Okay, so this is our homepage. Well, actually, that's our about page. But this is where you go to find out more about our firm, about the consultants that we have working together to make sure that we're giving you solutions on how to do your private governing. This is really straightforward. And right now, our website is catering to our small business community. So if you are a small business and you're looking for ways to structure your business so that you can create these private systems of governance that are outside of the federal regulations that you're used to, please contact us. You can go right here to our contact page, and if you're on Instagram, you won't see this, but you can click the link in bio so that you can get directly to our website. If you click the link in bio and then just click on our icon, then you'll be able to see, or click on the logo and you'll be able to get to the website. So we have this contact page where you can reach out to us, let us know what you're interested in, and we'll talk to you about the options you have to get started on creating your private system of governance. Now, this is something that you'll need to do slowly. You won't be able to do this all at one time. It's just like if you were to be starting a business and you needed to get different advisors for different things. You're starting a business, you might need a marketing advisor, you might need a financial advisor, you might need a technology person, you might need, a communications person or a customer service person. When you're setting up your system of private governance or all your systems of private governance, what you're actually going to be doing is doing it piece by piece. You're not doing it all at one time. So you can call us to figure out where to start. You can figure out what kind of learning path you need to take or what kind of structure is going to best serve your needs. And this is for your individual family. This is also for any of your businesses, especially if you are a small business. You need to have a system of self-governance available because as you can see right now, the government is trying to take you out. If you are a small business, the government is trying to take you out of the picture. They want you to either be elite or they want you to be poor. There is no more middle class that our common enemy it wants to allow for. The middle class is being attacked, okay, and they're either being pushed into one side or the other. And I'm telling you, it's not very much pushing going towards you being elite. They're trying to push you into the lower class. Okay, so we're going to do everything we can to fight back by using our own systems of private law to privately govern ourselves. Okay, so again, we'll be back tomorrow talking about more concepts of private law and private governance. So I do hope to see you back so you can learn some more and you can kind of reach out and talk to me about what you think will be best for you and your family when it comes to private law and private governance. This applies to every area of your life, your business and your individual life. So you want to give us a call and talk to us about all of that. Okay. Peace and love, you guys. I really hope that you guys are catching on to this as I'm talking about it because it is a little complex. It can have a lot of different implications in different areas of your life. So it'll be very beneficial for you to come to the understanding and for you to really hang on to this inkling of an idea that you don't need the federal government to govern your life. Okay. All right. I'll see you guys next time.